Court does call the case. People of the state of Michigan versus Justine Cheatham.
Good morning, Your Honor. Marie Caroline System.
Good morning, Rep. Jacob on behalf of Destiny Cheatham, who's on Zoom, and we do appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheatham.
Okay,
Do you have a camera, Destiny?
No, I don't. My screen is shattered.
Okay, I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're going to waive.
Yes, Judge.
Does
We're
either
waiving-
party have an objection to her not having a camera?
No.
I'm
Do you,
sorry.
do you object to her not having a camera?
No, Your
All
Honor.
right, very good. All right. It's going to be a waiver.
Yes.
Ms. Cheatham,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty. The pretrial will be set for July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate allowing my client to appear by Zoom. Thank you.
No problem. Yes, just one moment. Bond will continue in this matter.
Thank you, Your Honor.
Court does call the case, people versus Sean Odom.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Good morning to your honorable staff. If you please, this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You up?
Today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count one, and would ask that count two and the added count three on the amended complaint be remanded to district court.
All right, as to the amended count three, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right,
Respectfully.
you need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go run and talk to your client. Call it back up. Court does recall the case. People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Odom.
Thank you.
You up?
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna waive the formal reading, stand mute.
All right. Court will enter not guilty plea as to that count three. Maintain his plea of not guilty as to count two. Count one will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case. That's just been dropped at the second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for since March.
About a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or
You got
it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like.
well,
is right now.
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Answer to people. I want to go back to work.
Severe concerns that he can file court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also think because he's currently on probation in 15 for leaving with this same victim. So I don't believe he can keep himself from being in contact with her. And I have great concern for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to, he went to the police station. He went to the police station and made a police report in Ann Arbor, in Ann Arbor. That's one of the reasons for the contact.
So just, right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out. Your Honor.
Court called case People versus Jalen Kendrick.
Ally Zend on behalf of the people, Your Honor.
Oh, boy. Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Jalen Kendrick.
So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so.
Did you?
Mhm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
And Your Honor, today's date and time set for preliminary examination. At this time, the people are unable to proceed as to count one and would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for
Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Bernard Sanders.
Just say Charlie.
I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing a one-year offense. Upon a successful plea to that charge, count one would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth self you got?
Sir.
State your name.
Bernard Sanders.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, Your Honor.
I'm sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, Your Honor.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of People versus Stephen Watson.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismersky.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson.
All right. What are we doing?
Your Honor, as the court is aware, this is time and place scheduled for preliminary examination. People are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a DD complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. And Mrs. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as a count 3 or just amending count 2?
Just
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DV second.
wonderful. Thank you.
And you're waiving reading on that,
Yes, Your Honor.
and I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DV second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty And I believe there were issues with
Positive drops.
positive testing. My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact. The problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk and I'm for positive drops, and I can guarantee that. I'm just trying to get back to work. My job is.
No, I hear you.
Yeah, Judge Simpson,
But
I really learned my lesson. I understand the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I'm really just trying to get back to work. And
how many times do you think I hear that?
a lot, Your Honor, a lot. And
So tell me what makes you different.
Because I got 6 kids, I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that.
So if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything,
I would do the time in jail. But I'm
you're
not
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me after today.
You need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
I'll tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
See if they have something in place for you.
Okay.
Oh, yeah.
Please.
So I'm not saying no forever, but I'm gonna need something that
Thank you, Your Honor.
Thank you.
So,
Thank you, Judge.
Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. State your name.
She's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In Your Honor, to the concept of preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, as that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge rush hour.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fresh Hour.
Thank you.
Yeah, on continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Deborah Gilmore.
Katie Wismerski for the people.
Yes, Your Honor. Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count 1, that is dismissed. I'll maintain the not guilty plea as to count 2. I'll set that for a pretrial on
June 9th at 9 a.m. before Judge Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Washington.
Thank you, Judge.
Thank you, Bond. Go continue. Thank you. Okay. Court does call the case, People versus Brandon G.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunawith on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gevers.
Your Honor. Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30. Judge Slay.
Your Honor, could I address Ron briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
It's just a GPS location track.
I would ask the court, if we don't leave the tether on until tomorrow, she is in state today. So I would have concerns for her safety while she's here, and would ask that the tether be moved when she's back out of state.
His bond will continue. What I will do is I send an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Okay.
Thank you.
Thank you, Judge.
Yes, sir.
The cases of the People versus Brandon Carter. Didn't mean to wake you. No.
Going Brown, Deputy Chief Public Defender appearing on behalf of Mr. Brandon Carter. It has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh.
But he is unable to make this court date. He'd love to, but
So he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't.
All right, well, why don't I do this then? I'll find good cause adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have.
Then this is all messed up. Why? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of,
Yes, of June. Because of GT. So it's peanuts.
Oh,
So you ain't got anything?
June 17, 2025 at 12 noon.
Would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor. Like $10?
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,000, 10%.
Thank you, Your Honor.
Thank you.